for most of the last year and a half, we've had a vacancy problem. And to be more precise, almost 1 in 10 of our federal judgeships have been sitting empty. The DC Circuit is sort of a particular case study of that because it's an example of the obstruction that I think writ large has prevented us from filling judicial seats on the federal bench. One thing that's been bandied around quite a bit in the press, et cetera, is about the term court packing, which has been used with respect to the DC Circuit. And as you well know, in the 30s, President Roosevelt had actually attempted to change the number of seats on the Supreme Court to sort of increase the number of seats. And it's important to say that what's happening in the DC Circuit is not increasing the number of seats, it's actually filling existing vacancies that are open. And so I think just as a factual issue, so that at least we're arguing about what to do, but we're agreeing on the facts, this is not an instance of court packing. In fact, I think some analysts have said that the Court Efficiency Act, which was a bill that was introduced by Senator Grassley to cut 3 seats from the DC Circuit, that actually would be a better example of tempering with the number of existing judgeships. Some people have said court packing in reverse, and so whatever you want to say, but if the closer analogy to changing the number of judgeships would be actually the attempt to reduce the judgeships, not the attempt to fill existing open seats.